Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's Monday. That means the Supreme Court orders list is out. Now, last week we did this video right here, and we expected and we predicted that it would be a huge bloodbath at the United States Supreme Court today. Turns out we were wrong. Okay, it was not a bloodbath, and we're going to explain why it wasn't a bloodbath because we have a new theory of what's happening with a lot of these cases. So today, let's spend a few minutes, let's get you educated, and let's talk about all the gun cases spared today by the Supreme Court. Okay, America, it is Monday. You will be seeing this video either in the afternoon or early evening, depending on where in the country you are. We did get up early this morning. We decided not to do a live feed, and I'm really glad we didn't because it would have been a big, fat nothing burger. There were 41 cases dealing with Second Amendment issues before the United States Supreme Court last Friday for conference. As it turns out, almost all of those cases are still alive. Now, I first want to talk to you about an interesting case because it's a pro se case, and we brought it up once before, and this is a matter of Gardner v. Maryland. Now, we kind of joked about it on the first video, and again, I'm going to apologize to Ms. Gardner. I've had an opportunity to get into the petition. I've had some other lawyers get into the petition as well, and there's some teeth here, okay? And the issue in that case is whether or not Miss Gardner, who was a licensed concealed carrier out of the state of Virginia, should be convicted for a crime because she had to display a firearm when she was in Maryland in lawful self-defense. It's an interesting issue and one that the Supreme Court needs to decide. Now, Miss Gardner filed her petition back on October 22nd of this year, a pro se petition. And like I said, the minute I pulled it up, I was like, there's something different about this one. Well, the difference is that Miss Gardner is represented by Miss Gardner. The state of Maryland also kind of scoffed at it, and they filed almost immediately on November 3rd a motion to waive their response. Basically like, Judge, we don't even want to respond to this thing. On November 6th, the case was actually scheduled for a conference on November 21st. And since it was scheduled for a conference on November 21st, on November 12th, the Supreme Court sent notice to the state of Maryland saying, no, actually, we want to hear from you on this. Now, the state of Maryland has since filed a motion for an extension of time, so their response brief is now not due until January 26th. I'm assuming this case will be scheduled for a conference sometime after the first of the year, but Gardner v. Maryland is still alive and well. Okay, as you know, the big issue that was before the Supreme Court on conference last Friday was the challenge to 18 United States Code Section 922G1, the felons with firearms rule. There were 39 cases on conference on Friday that dealt with some type of challenge to 922G1. Of those 39 cases, only one has actually now had its petition denied. That case is Jenkins versus the United States. The other 38 cases, all of which are challenging 922G1, remain alive, including Duarte versus United States, a case that we've already done a video about because we believe that this is a very important petition. Why do I think all of these cases survived and didn't just get chopped? Here's what I think is actually going to happen. There is, like I said, there was 39 on Friday alone, and these are not the only challenges to 18 922G1. There's a litany more of them. And we got this case out there, United States versus Hamani. There is clearly going to be some language in the Hamani opinion that is going to further delineate who can be disarmed, who cannot be disarmed, who has passed the restoration of their Second Amendment rights. What I'm now anticipating is that many, not all of them, but many of these challenges to 18 United States Code Section 922G1 are just going to get kicked down the road until we get a written opinion in Hamani, and then they're going to get GVR'd back down to their courts. And we all know how well GVRs work. We all know how well the lower courts get the message, a la what happened in the summer of 2022 when we GVR'd a bunch of assault weapon bans and magazine bans back down to the lower courts following Bruin. And well, here we are with both of those issues now, again, on petition to the United States Supreme Court. The other big issue was a challenge to 18 United States Code Section 922G5A, which is the prohibition on illegal aliens possessing firearms. There was a case out of the Seventh Circuit. We had covered that case already. matter of Carbajal Flores versus the United States. That petition was denied, which means the holding of the Seventh Circuit, which said that people who are in this country illegally are in fact not part of the people as contemplated by the Constitution, remains good law in the Seventh Circuit. And mark the day on the calendar, it may be one of the few times that we here at Washington Gun Law actually agree with the reasoning of the Seventh Circuit. Oh, and on a final side note, there were 2 per curiam decisions issued today. So the day of the per curiam or summary reversal from the bench is not dead. Why the United States Supreme Court didn't decide to do that in Wilford v. Lopez is beyond me, but we did have per curiam rulings issued in Clark v. Sweeney. A very bad day for Mr. Sweeney, who had been convicted of second-degree murder, had ultimately appealed all the way up the chain, finding no success whatsoever. The Fourth Circuit finally reversed his conviction, but did so on grounds that Mr. Sweeney himself had not even petitioned for. So the United States Supreme Court has reversed that reversal, and Mr. Sweeney is still guilty of murder in the second degree. We also had a per curiam decision in the matter of Pitts versus Mississippi. In certain types of criminal cases in which there are child victims, sometimes the children do not have to testify live in the courtroom. It can be done through other methods to theoretically reduce the trauma that children suffer from having to testify in those situations. The Mississippi court had basically said that the law was a blanket application and all children witnesses testified that way. The Supreme Court said, no, actually, you need to make specific factual findings on that. And because you didn't, we're going to reverse it and remand it back down to the lower court. So the days where the United States Supreme Court can just step in and say, nope, this is a bunch of BS and we're going to flip it right now, they are still alive and well. You just probably will never see that again in a Second Amendment case. Okay, there will not be a conference this coming Friday because it's Thanksgiving weekend, but remember on December 5th, America, we have 2 huge magazine ban cases on for conference. The first one, of course, is the granddaddy of them all, Duncan v. Bonta. We also have Gators Customs Guns versus State of Washington, so we're going to carefully watch those 2 cases, and we'll give you an update video as we head into that December 5th conference so you know what else is at stake. All right, now we'll go ahead and take today's orders list. We'll link it up down below so that you don't have to take our word for it. You can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is right down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people.
Right.
We come from a significant gun background.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.